This is Faisal Elkhatib and Miss Stephanie Arcenty.
Hello.
We are here today on housing issues at Better Informed Housing. You can call us. It's a live show at 312-738-1060. The number's at the bottom of your screen. And we are Facebooking live to a bunch of people out there. Hi, everyone. You can reach out to us. We are... Oh, wow. We need to zoom out on that one a little bit. Okay. Better Informed Housing. You can reach us at betterinformed.org. Address is 218 North Jefferson, Suite 103, Chicago, Illinois. You can call at 312-533-2688, or you can email us at neighbors@betterinformed.org. And again, this is a live show. You can call at 312-738-1060. So, we're here with attorney Stephanie Arcenty. Thanks for joining us today.
Thanks for having me.
So, one of the things we talked about the last time we were here was about foreclosure defense and some things that are available for people that if they get into trouble. I know we're completely out of the housing crisis essentially, and there's a boom in housing. However, there's always going to be foreclosures, and there's always going to be people who need help in this realm. And we want to make sure that we get this information out to people so that they have it. So, as part of our housing initiative to help people and get information out there into the neighborhoods, we're going to talk about foreclosure defense. So, Steph, last time we talked about, we said that there weren't really a lot of defenses, and really the world of defense has gone into the world of counterclaims. Is that correct?
That's correct, Faisal. And we touched a little bit last time on some of those counterclaims. Didn't get into too much detail, but the Real Estate Settlement Procedures Act was one thing that we talked about last time.
Correct.
And I do have a list of some of the provisions under the Real Estate Settlement Procedures Act here. If we can zoom into that a little bit more so you can see it. Thank you.
So essentially what you're saying is these are some of the primary, or there's some key federal statutes that exist out there that can be used to protect the borrower from some of the predatory practices of lenders. Is that correct?
That's correct.
So you said the Real Estate Settlement Procedures Act, that's RESPA. And what is that? We'll go through, and what we're going to do is we'll go by one, and we'll talk about what each of them are. And then we'll come back and go one by one through them and see what each of them, how they can be applied in certain facts and scenarios, and then what does that mean when they do violate it, and what the outcome is. So, RESPA deals with what exactly?
It's sorry. It's a statute there for the protection of consumers in residential loans. So any residential loan that is a federal loan is covered under this.
So residential loans that
Yes.
take place when you acquire property and you do a refinance, is that correct?
It's it's for purchases as well.
So if I purchase a property as a consumer who's buying a house under a consumer type loan.
Right.
This is the RESPA is what covers them in terms of how the transaction is going to be governed, how you go through the transaction, right?
That's correct. And then it also covers what the lenders are required to do after the transaction occurs. So these particular subsections of RESPA that we showed here are requirements for lenders.
So all these are RESPA provisions.
Yes, they're all under Regulation X, and they're servicing requirements for the servicers of loans. And so these all relate to mortgage foreclosure defense because they are some requirements that you can request to be enforced if you are in foreclosure.
So these essentially are the rules that govern the lenders after you've done your closing, after you've bought the property or taken out the loan. These are specific rules that the lender must follow.
That's correct.
Now, as a whole, if they don't follow these rules for whatever reason, what is the repercussion to the lender?
So what you can do is file a counterclaim and try to assert You're right.
Before we get to the counterclaim piece,
Yes.
so if, let's say they broke the rule, let's say we were able to push them all to the limit and we win, what is the result? What can someone expect that they would get in the event that there was sorry, just waving to Facebook Live people. What can they expect if they see, if they win? Like if they really prove that the lender did this?
That the lender violated the statute, you can get what's called actual damages and statutory damages.
So what are the statutory damages
potentially.
amount?
So for each violation, it's $2,000.
So each time they make a violation or each category violation?
I guess it depends on the court, but how the court interprets a violation. But you could ostensibly ask for the statutory amount for every violation that occurs. So in any case, your actual damages, if you are in foreclosure, either while this violation occurred, before or after the violation occurred, you can ask for actual damages in terms of what you're paying to your attorney to represent you in foreclosure if it's delayed because
attorney's fees are
of
covered
their
under these, right?
violation. Right, so
These
the
are
attorney's
fee-shifting
fees,
provisions.
that's true, but that's fee shifting under RESPA. So what you pay to prosecute, right, your counterclaim is what is covered under the fee shifting provision in RESPA. But if you also have to pay, right, to defend a foreclosure
I
complaint,
see.
right,
Okay.
then you can ask for those fees as
Gotcha.
well as
So-
actual damages.
So the work that the attorney does in order to file the counterclaim itself and everything related to the counterclaim is one set of fees, but also separately, if you're defending on the foreclosure side, that could be included as part of the fees and the damage that occurred. That's
Right.
part of the actual.
And all the fees and interest that accrues, as the foreclosure is proceeding, anything, in terms
In
of.
order to offset what they're trying to charge for
right,
non-payment, whatever the case may be.
exactly, yeah.
So we've got attorney's fees that are shifted, so then if they are found guilty, essentially, or found liable,
Okay.
trying to take it down to layman's terms, so if they're found liable and that they did really violate the act, then they have to pay my attorney's fees or pay the borrower's attorney's fees, any actual damages, plus the statutory fee, which is how much per violation? You said $2,000 per violation, right?
That's correct.
Okay, so talking quickly, let's look at the overhead again and let's see kind of what are the options. So we've got the first one, which is mortgage service transferring. Can you explain a little bit what that is?
Sure. So I know a lot of people who have mortgages on their homes knew about the fact that many times your servicer will be different than maybe the original lender, and that's because the interest in your mortgage loan has been transferred either to a new holder or owner and or a new servicing entity.
So by interest, you don't mean the actual calculated interest, you mean the entity that owns the loan sold it to somebody else.
That's right, and a lot of times what happens, either they sell it to someone else or the servicer changes to another entity. So the servicer will switch. So what I mean by servicer is the entity that reaches out to you and provides you your monthly statements. And actually takes care of all the paperwork, all the communicating,
Gotcha. So the one
and,
who
and
services-
tracking of your loan.
So servicing the loan is different than owning the loan.
That's correct.
So the servicer is the one who collects the payments, processes the paperwork, and takes care of all those things. And so when that servicing changes, technically, if someone's still paying their mortgage, they would need to know that the money that they're paying, whoever they're paying, is going to the right entity.
That's
And
right.
that transfers properly.
That's right. And actually, there's also requirements that if the holder or owner changes, those notices are required to be given as well. And a lot of times, the owner and holder of your interest in your mortgage loan can also be the servicer. So it's a little confusing.
So the bank could be the same as the servicer.
That's right.
But in most cases, because of the secondary markets and the resale of loans and Fannie and Freddie and those different types of entities and hedge funds, most of the time the loans are sold off and being serviced by somebody else.
A lot of the bigger banks will service their own. And so, like Wells Fargo and Bank of America and so on, and Chase, they'll service their own loans. But a lot of times, if you had somebody who's like a smaller lender
or a mortgage broker,
right,
so
exactly.
like servicers would be like SPS, Nation Star, Cenlar, Ditech. Those are the types of services that are out there. I'm sure there's a bunch. Green Tree Servicing. Mr. Cooper now,
Rushmore.
Yes. So there's a bunch of services.
Right, that's right. So that shifts, right? They're required to send you notice of that shifting. So both the prior servicer needs to give you notice, and the new servicer needs to give you notice.
And what
this is where you send your payments.
So it's a letter that sends out saying, hey, we're sending it to somebody else, and someone says, hey, now send your payments here.
Right.
And if they don't send that notice properly, or they don't send it in time, and they can't prove that they sent it, and you don't receive it, that's a potential RESPA violation.
That's correct.
And it doesn't expire, or is there statute of limitations on that?
I can't remember what the statute of limitations is. I think for RESPA, it's a few years, but don't quote me on that.
I'll have to come back next week and look at that.
Okay, we'll do that.
So looking at the next round, we've got the error resolution procedures. Tell me a little bit about that. What exactly is that?
Okay, so error resolution procedures cover circumstances in which you find that there's an error in the servicing of your loan, like say for instance, an error in the way that certain payments were applied or not applied with respect to taxes and escrow, and any kind of error that you can see if you made a payment and they didn't receive it, and
so any mistakes that are processed by the servicer. And essentially, this is their procedures to how they manage and handle these mistakes. And if they don't do the mistakes the right way, then they could be again liable for each violation.
Right.
So they've got multiple mistakes that could technically end up potentially with multiple violations.
Potentially. So you want to alert your servicer of these errors, right? And so the way to do that is to send what's called a notice of error. And
is this similar to the old QWR?
It basically what it used to be.
It.
Well, so a QWR would be a qualified written request is what that stood for.
Correct.
And right now that's called a request for information, which is the next subsection.
Gotcha.
So you can not only if there's an error, there's a route to take in order to notify your servicer of that error, and they have to respond within a certain period of time, and they have to find some sort of resolution or respond with respect to their attempts to find a resolution to that error. Within a certain period of time. And then also if you would just generally like information about who the owner of the loan is, for example.
That's in the request for information.
Right, you can request that in the request for information.
Gotcha.
You can request your payment history in the request for information.
So just to update, and I should probably show this to the people on Facebook Live, but we'll do that in a minute. So we've got so far under RESPA and Regulation X within RESPA, we've got mortgage servicing transfers that have to follow certain requirements, certain procedures, and if they don't, then there's a mistake. And those mistakes could result in money being paid to you, which is a great defense when it comes to foreclosure. The next piece is the error resolution procedures. So if they don't actually address the errors that have come up, then those could be an issue, correct?
Yes.
So just to remind everyone, this is a live show. You can send us messages or text messages on Facebook, and we will get those. Say hello to everybody out there. Or you can call us live at 312-738-1060. We're talking here with Stephanie Arcenty about foreclosure and about foreclosure defense. And really the big defenses of foreclosure is no longer defending, but filing counterclaims. And so we're next on the overhead, and what we're looking at here is we did the request for information, where you have specific requests about the servicing, about the owner of the loan, about details regarding the loan and those details. And if they don't respond within a certain period of time, as Stephanie was saying, results in a possible violation that can be pursued.
That's correct.
And then you've got early intervention requirements and loss mitigation procedures. Can you talk a little bit about those two?
Sure. So those are some of the things that I talked about last week. And actually, I want to correct myself because I did get a little bit of this wrong. We talked about how we used to have a grace period notice requirement in Illinois that the servicer would have to send out a notice telling the borrower if they're in default and that there are loss mitigation options available and how to contact a housing counselor and so on. So last week I said that the notice that's similar to that, that's required under RESPA federally, would also require an amount that you're in default. And actually, that's not a requirement. All it is essentially saying that you are in default. Here's your housing hotline that you can call to see if you can contact a housing counselor to resolve that. There are options available to you. So just to get that information out is one of the requirements. Now, like I said last week,
And that's the early intervention requirements.
that's correct.
So essentially, they got to send out notice to every borrower who may have missed a payment or is about to miss a payment or is late,
Right.
and telling them what options they have available to them in order to mitigate their potential foreclosure, to prevent it.
Right, and it has to be in writing. They also have to make some attempt after a certain period of time of quote unquote delinquency in their world to make live contact with the borrower.
Oh, so they have to reach out to the borrower physically or on the phone and call.
That's right. So they have to make
Gotcha.
some sort of live contact to make what's called under this section a good faith effort.
So is that different than the face-to-face meeting required under the FHA?
That's a whole different thing. Yes.
Okay.
It could be over the phone with FHA. What Faisal was talking about is the Federal Housing Authority.
Fair Housing Act.
Sorry.
The Fair Housing Act. Federal Housing. The FHA, the Fair Housing Authority. Federal Housing Authority. I'm
Yes.
so lost right now. Wow.
Housing and
that?
Urban Development, HUD, right?
Gotcha, under HUD.
Okay, so FHA HUD it's a government insured loan, right? It's a specific type of loan. And when FHA and HUD insure your loan, that imposes additional requirements on lenders to reach out to you face-to-face, in person, to attempt to do that, what's called a reasonable attempt to reach out to you.
Which is similar to this, but this one's over the phone or it needs to be a live contact versus having a face-to-face meeting.
That's right. So
Gotcha.
this is for every federal every loan.
Every residential loan that's issued must have some sort of notice that's issued as part of an early prevention program.
That's right. So and so that this is RESPA, and then the FHA HUD would only be in reference to FHA HUD insured loans. So in any case,
So the next one is the loss mitigation procedures. Right?
yes.
So loss mitigation procedures. And before we dive into that one, I remind everyone we are a live show, 312-738-1060. And you can reach us at betterinformed.org. We're helping to build the future, save the community, and help the neighbors. And provide education information to the community in order to better the community to have housing at your fingertips. And you can reach us and contact us at, we'll get that here for a minute, betterinformed.org, 218 North Jefferson, Suite 103, Chicago, Illinois, 60664. Oh, we gotta zoom out.
Yeah.
Let's try
There we
that.
go.
There we go.
boy,
All right.
That's a zooming.
So, or you can email us at neighbors@betterinformed.org, and we're going to show really quick to the Facebook Live people the different opportunities out there. I hope you can read that, unless it's backwards. But those are the different options that are out there in terms of statutes. So, let's talk about the loss mitigation piece, right? So, under loss
Wrong way.
mitigation.
There you go. Oh.
Under loss mitigation, what exactly is that in terms of violations or procedures that they have to follow?
Sure. So if you submit a loss mitigation application and that's deemed either facially complete or incomplete, so there are certain circumstances in which they have to respond. In any case, they have to respond to indicate that they, meaning the servicer, has to indicate that they've received that application. Then, if there's any documents that are missing, they have to inform you within a certain period of time that there are missing documents, what those documents are, and give you a time frame with which to submit those documents. I don't know if the time frame with which to submit them is required, but normally they do.
So when we're talking about loss mitigation, we're talking about essentially when a person's gone into default. So they've stopped making their payments, they're running into some financial trouble, and so they've decided to request for a loan modification or a deed in lieu or a short sale. Okay, and we can spend
Right.
we have historical shows, and back in our library you'll see where we talked about short sales, loan mods, and and deeds in lieu. But in this case, loss mitigation essentially is to mitigate the losses that are taking place.
That's right, to avoid foreclosure sale.
Right.
Essentially, anything that you would try to do in an effort to avoid a foreclosure sale on your property.
Or a deficiency against you, so that way you don't.
That would result from a foreclosure sale potentially.
Correct.
That's right. So
Correct.
then resolve that issue.
So in the loss mitigation piece, there's certain documents that the lender will require that they have to put together and send them out.
Right. So that would be your application, right?
That's
So-
the application for loss mitigation. And now that they've
That's
got the
correct.
application put forth, they have a requirement to review it, look at it, and respond within a certain period of time in order to ensure that they reviewed it effectively.
That's
Are
right.
there good faith provisions that they have to have really looked at it, or could they have just said, "Oh, we got it, thank you, denied"?
So, right, they have to give you a reason and to tell you, or, you could try to challenge it if you don't think the reason is sufficient. So
And that's
there's an
within the
appeals
act.
process.
Within the loss mitigation procedures requirements.
And so you also, if there's a foreclosure action pending, right? So this is where we get into the ability to try to stay that foreclosure action or a violation with respect to moving forward with the foreclosure, right?
Okay,
What's called
right.
dual tracking. We covered that a little bit last week.
Correct.
So there's a prohibition on dual tracking,
So
where
this loss mitigation procedures statute 1024-41 under 12 CFR, they address dual tracking in that statute.
That's correct. So if the lender is, for instance, if there is a loss mitigation application that's been submitted that's facially complete, right, and the lender is supposed to be considering it, the servicer, right, the plaintiff in your foreclosure case cannot then move to what's called judgment against you, and they also, in other cases, can't proceed to a foreclosure sale if that's the case.
So if you've got a pending application and they haven't approved it or denied it, they can't go to sale?
It has to be submitted within a certain period of time prior to the foreclosure sale.
And that's the 38-day requirement.
37, right, 38.
37,
right,
yeah.
okay. So, before 37 days, right. So, yes, so, and there's also a requirement that the judgment can't be had, or they also can't refer the case to foreclosure at all and accelerate the full amount and then refer it and file the foreclosure complaint if you've submitted a loss mitigation
pending.
application and it's facially complete and pending.
And that could be
Exactly.
loan mods or short sales or even deeds in lieu.
That's right, any loss mitigation application.
Very cool. And so the last piece I saw, that let's look at the overhead one more time, is you talked about the Fair Debt Collection Practice Act. Now, just letting everybody know, there are more than just these. There are tons of consumer regulations, which include the Telecommunications and Practices Act, the Fair Credit Reporting Act, and each one of those have their own nuances and their own available remedies. But we're just kind of highlighting, touching upon these possible and available remedies and statutes that protect the consumer protection statutes. And so the Fair Debt Collection Practices Act, just Oh, we are almost out of time. Actually, we're pretty much out of time. So what we'll do is we'll talk about the Fair Debt Collection Practices Act another time. Essentially, just briefly, that is how the collection agencies and companies can come after you to collect money from you. They have to follow certain rules and guidelines, but those can be counterclaims that can also be filed in a foreclosure. And I want to say thank you very much, Stephanie Arcenty, for joining us. She's an attorney who
you.
practices foreclosure defense. And lastly, really quickly, we are Better Informed Housing. We are located 218 North Jefferson, betterinformed.org, 312-533-2688, or you can email us at neighbors@betterinformed.org. Again, my name is Mahmoud Faisal Elkhatib. It's a pleasure to have you this evening. Thank you to all those at Facebook Live. Have a good night.